Good morning and welcome to the Missouri Court of Appeals, Eastern District. We're delighted to be sitting here at St. Louis University Law School for our 11 o'clock docket. We only have a single case on the 11 o'clock docket. I'm going to ask the parties involved when the case name is called to the attorneys for the parties to stand and indicate their name, who they represent, and how much time they'd like to reserve for oral argument. The maximum amount of time is 15 minutes for each side and 3 minutes for appellant's rebuttal. Because we have a large audience today, I would ask the attorneys to maybe give some of the underlying facts. We've already read the brief, so we're familiar with the facts, so that the audience will understand the position of the case as well. I'll be liberal in granting extra time if it's necessary to do that. My name is Judge Larry Mooney, and I'm honored to sit today with Judge Jim Dowd and Judge Kurt Odenwald in hearing this case. The case on the 11 o'clock docket is State of Missouri ex rel. Justice for Ken, Kathy Allen, and Vincent Bonderman, appellants, versus Robert E. Parks and Franklin County Prosecuting Attorney's Office as respondents.
Your Honor, I'm Michael Benner. I represent the appellants, Justice for Ken, Vincent Bonderman, and Kathy Allen.
Okay. And how much time would you like for argument?
Could be 15 minutes.
Okay.
Probably use 4 hours, but I don't think that's going to be of service to anyone.
Your Honor, I'm Ben Wesselschmidt, and this is Mark Piontek from Sanford, Phoenix, for the respondents, Robert Parks and Franklin County Prosecuting Attorney's Office.
Will both of you be arguing, or?
Just me, Your Honor.
And how much time would you like to reserve? Let's go ahead and we'll proceed with arguments.
May it please the court? Thank you. As I previously said, Michael Benner for the appellants, Justice for Ken, Kathy Allen, and Vincent Bonderman. Seems fitting that we're here at the law school today on this case.
Can you make sure you speak closer to the microphone?
Oh, I'm sorry, yes, I will. I think it's very fitting that we're here at St. Louis University Law School today. I'm here on an appeal that is 100% moot at this point, asking for you to render a decision based on the mootness doctrine and exception. It involves attorneys and not following the rules of professional conduct, ethics, all those things I think in law school that maybe we pay attention to a little more then than we do in practical practice, but they're still very important. The facts of this case, I'll do my best. This did happen, and it has happened, and that's why we're here today, and I can't believe myself. This is the case that should never be here. It is a case of first impression. I've never seen a victim ever try to remove a prosecutor from a case in my life. I could not find any case law on that. I don't believe the judge at the trial court level could find case law on that, and I don't think any of the respondents' attorneys could ever find case law that was truly on point to what we're dealing with. November 2nd, 2016, Ken Allen was murdered in his home in Washington, Missouri. Subsequent to that, the next day, 3 individuals were arrested for his murder, and they were indicted by the grand jury for the counts of murder in the second degree, burglary in the first degree, and receiving stolen property. That happened by January of 2017. Kathy Allen is the victim's daughter. She was very involved with the prosecutor's office under the Victims' Rights Statute, trying to find out why and how her dad died. In March, in response to her inquiries of how her dad died, the victim's advocate at the prosecuting attorney's office in Franklin County, directed by Robert Parks, the respondent, told Kathy Allen in an email that they didn't know how she died, how her dad died, that there was no bruising and no marks around his throat to indicate any kind of cause of death, according to the medical examiner. Subsequent to that, Kathy soon followed that. They sent her the medical examiner's report that said there were strap muscle hemorrhaging and marks around bruising around the neck. In the summer, by August 2017, he conveyed plea offers to the 3 co-defendants. It was to amend the murder in the second degree down to an involuntary manslaughter charge with a certain sentence of 7 years, burglary first with a sentence of 10 years to be served. The Department of Corrections in dismissing the receiving stolen property count. Through his victim's advocate in emails and personally in conversations that she recorded, he told her that this was a violent felony under Missouri law and that they would have to serve 85% of their sentence before being eligible for parole. He did this in writing, and he did this in person. He did this to the papers, when in fact, it was not a violent felony, and there was no 85% mandatory minimum sentence to ever be served by these defendants. There was a plea hearing on 2 of the defendants, Brittany Robin and Timothy Wonish, that happened in September of 2017. Judge Gail Wood heard that plea. He rejected it for being too lenient based on the circumstances in this case. As a result of the rejection, Robert Parks, the prosecuting attorney for Franklin County, offered a new plea offer to the defendants that was more lenient than what they were initially offered. There was a stage in here where Judge Gail Wood had to retire because of mandatory age laws in Missouri for judges. So that happened in November of 2017. Judge Craig Hellman was then appointed by the Supreme Court to serve out the rest of his time on the bench, and he took over the case in December of 2017. That's when a new plea was presented by Robert Parks. That was more lenient than the first one that was rejected by Judge Woods. That plea was for 7 years on the involuntary manslaughter amendment and 7 years on receiving stolen property at the same time of dismissing then the burglary in the first degree, the only B felony. That was also promptly rejected by Judge Hellman, which then, and throughout this course of conduct, there's more writings from Mr. Parks and his assistants and victim advocates saying this would be an 85% mandatory minimum sentence. In January, after having a hearing about rejecting their plea, Judge Hellman recused himself from this case. At that time, there were no circuit judges left who could be on this case. Should be noted that Kenneth Allen, he ran drug court. He was a drug court administrator for Franklin County since its inception in 2000 and 2013. He had had his contract extended, and shortly after having his contract extended for a year by OSCA in 2013, it was terminated by OSCA, and he had, at the time of his death, had sued the prosecuting attorney's office, the sheriff's department, because of the involvement of an assistant prosecuting attorney in the case for his dismissal. And this led to his knowing numerous judges in Franklin County. After Judge Hellman recused on this one, then it got appointed to Judge Wright out of Warren County on a special judge because there was no judges left who would be in Franklin County without a conflict. So Judge Hellman then rejected Robert Parks, excuse me, I'm very familiar with the facts as I filed the petition. Robert Parks then dismissed every charge that was filed against the defendants except for the involuntary manslaughter, including charges that were unrelated to the murder for felony drug possession, resisting arrest, and numerous other felonies on Timothy Wonish and Whitney Robbins. In February 2018, the appellants filed a writ of mandamus requesting the court to mandate Robert Parks recuse or disqualify himself based on his numerous violations of the Missouri Rules of Professional Conduct and his appearance of impropriety that he had created in the case, and his fact that he had not done so. That brings us here to where we're here today. Subsequent to that, there was a motion to dismiss filed for failure to state a claim upon which a cause can be granted, and the court, on its own motion, taking the case really under the merits, which is the substance of our appeal, instead of ruling on did we have a cause of action, did we properly file a petition, ruled that on the merits that there was no situation under the court's opinion that we could ever have a disqualification of the prosecutor's office without completely ignoring, without an evidentiary hearing, which is the basis of why we're here today, without taking any facts into evidence, ruled that the appellants did not have a case.
Let me interrupt you a second. I was struck by the trial court's order in this case, by some of the language that was used. And let me just read a little bit of it to you. In this case, the relators wish to disqualify the prosecuting attorney because he is doing a bad job, literally letting 3 defendants get away with murder. If the allegations in the petition are true, this court agrees that the conduct of the respondent is despicable. That horrible conduct does not authorize this court to disqualify the prosecuting attorney. The Missouri Supreme Court recently ruled in a case coming out of the city of St. Louis that a witness, there happened to be police officers attempting to disqualify the prosecuting attorney, were unsuccessful because of the unfettered discretion that the prosecuting attorney has. Judge Missy went on. The most obvious similarity between this matter and the Eckelkamp case is the presence of prosecuting attorney Robert Parks. In Eckelkamp, Mr. Parks refused to enter into plea negotiations with certain defendants. In this case, he refuses to fully prosecute other defendants. No one could argue that Mr. Parks is being consistent or even-handed. Just as the defendants in Eckelkamp had no right to plea negotiations, so the relators, your clients, in this case, have no right to have Robert Parks seek appropriate punishment for the people who killed Kenneth Allen. The relators have asked this court to provide justice for Ken. Unfortunately, it is outside of the power of this court to provide that justice. The people of Franklin County depend on their prosecuting attorney to do that. It appears they are being let down. If the allegations of the petition are true, then the people with firsthand knowledge of those facts should file a bar complaint. The voters of Franklin County should make themselves heard. The court, however, cannot remove the prosecuting attorney from this case based on the allegations in the petition. I'm sorry to read such a long thing, but I was astounded by the direct language by Judge Missy. Why isn't he right?
Well, first and foremost, he's confusing the fact that while the essential outcome is the same, he would not be disqualifying Robert Parks. The writ of mandamus would be compelling Robert Parks to do his own duty, that he should have realized as an attorney under the rules that he needed to disqualify.
What's the difference?
It's a bar complaint is punitive. It's after the fact. It does not prevent a conflicted attorney from representing the state in this case. The rule is clear. It says he shall not, not he made in his discretion. It says his attorney shall not represent a client if there's significant risk in the representation of one or more clients will be material limited by the lawyer's responsibilities to a third party. There's also rules.
But you're not the client. Your clients are not his client.
They're the third party. He has a as a crime victim, he has a material responsibility to tell the truth under the rules also to third parties.
What's the evidence? If you had a hearing right now, what's the evidence that he was conflicted?
We never able to have a hearing. That's part of the reason why we're here. We never had an opportunity to present any evidence because we didn't have an opportunity to have a hearing, and that's what the rules and the case law do allow for us to have in this case. There was my writ. There was a preliminary order issued. There are definitely questions of material fact in this case. The Judge Missy did not assume we're all true on what we said. He assumed that they were very bad actions, but he didn't give us a chance to present any evidence that would have supported our position. How can we make a case if we never had that opportunity in the first place? He dismissed our action without even an iota of evidence.
So I think in our review, then, we should take certain facts as true, since we're reviewing what was in your petition. So you alleged in your petition, number one, that the elected prosecutor, inferentially, by inference, may have had a motive to be less than forthright in his prosecution because of animus towards the deceased, because of the conflict between him as a drug court provider and an assistant prosecutor, and that he made misrepresentations, both factual as about to the cause of death and legal as to the legal consequences of a plea to the victim's family. And third, the two judges, even acknowledging the discretion a prosecutor has, rejected his plea agreements as far too lenient?
Yes, and the evidence, if I can backtrack a little bit for Judge Dowd, if you don't mind, the evidence we would have presented was that there was an ongoing civil case in federal court where the crime victim was suing the prosecutor's office, an assistant prosecuting attorney from Franklin County, that there was a definite appearance of impropriety in the prosecutor's office, which is a reason to disqualify under the rules, based on everything, the culmination of every fact in this case, not just one particular fact. When you put one on top of the other, it really starts to create an appearance of impropriety. And yes, given all of that, that's why we're here today, and there was an asking to have Mr. Parks removed. I'm doing it myself, it's easy to confuse. To ask Mr. Parks to perform his duty as an attorney, a member of the bar, and as a prosecuting attorney, and not to be involved in a case in which he has a conflict of interest.
You stated earlier, you filed the writ to have him do his duty. You say at the very beginning that this is now moot. I know in the brief, 2 of the 3 had already pled, therefore it was moot. Has something happened with the third individual?
Mr. Parks retired from office at the end of this last year for the term, so it has become every issue, I guess, at this case, it is moot because there is no person to have a writ compel. There's a new prosecutor for the third defendant. So in that fact, it is moot. We are obviously here having an argument today, so we don't fall within the first
So
exception. of the mootness
it is
doctrine.
not your claim that the newly elected prosecutor has a similar conflict of interest or duty to recuse?
No, and the office itself that was part of the filings too, you cannot bring a writ of mandamus against an office. You
Did
can only-
Robert
you can only
Parks
bring it
run
against
for
the person.
re-election, or did he not run?
He retired after 20 years in office,
I see. Okay.
which would have been part of the evidence that we would have been presenting was would have been that based on that he had no recourse. He could do whatever he wanted. A prosecutor has discretion. It does have a lot of discretion. They do not have discretion to violate the rules of professional conduct.
Yeah.
They have to abide by the same rules as everyone does.
I think I can pick up in the trial judge's language that he had some sympathy for your cause. I think the difficulty he was running into is, I mean, a defendant in a criminal case has a right to effective representation. You sort of posit the issue, well, does a victim have a right to effective representation? The prosecutor represents the state of Missouri, not the victim legally. And I think part of the difficulty is the trial judge would struggle, well, if you allowed the disqualification of a prosecutor to be enforced, where would you draw the line? Could that be done? We've had a lot of conflict lately about prosecutors in this metropolitan area about could defendants or witnesses or others claim that the prosecutor was not fulfilling their duty and force disqualification. What's your thought on where the line would be drawn?
In our case, and I'm not sure, I'll be humble, I'm not sure where the line should be drawn. I don't know if we could have an academic discussion forever on that. I do know that we brought our case on behalf of not just the victim and Justice for Kim, but on behalf of the citizens at large.
Well, and if you bring it on behalf of the citizens, then I think Judge Mooney raises a very good point. Where do you draw the line? Can any citizen feel that a prosecutor is not diligently representing the victims or the state in aggressively prosecuting and then seek a writ of mandamus?
If I can put it into terms of this case somewhat, I would say early on when he first had lied just about the cause of death, I don't believe that would have been a line. I don't believe there would have been a line when he first lied about the mandatory 85%. I don't know if there was a line when he then made the sentences more lenient after a judge told him they rejected a plea because of that. I know a line starts forming when he starts dismissing every charge against them, and he's in a battle with the judiciary and judges over not accepting his pleas and continually lies to victims. It's an ongoing course of over a year's worth of conduct.
A prosecutor has much discretion as to what charges to bring to begin with. And I realize here you do have one of the clients, Kathy Allen, is a relative. Yes. So she is a victim. And there are victim rights under statutes. Mr. Bannerman, I think, is part of the general constituency you're talking about. So I think you do have two different situations there and a basis to make the argument.
And that makes this case unique. I think it is why we are it's a case of first impression. And I honestly hope that this never comes before the court again, because that means the system worked. If the system worked, there would never be a motion to disqualify, because every attorney would get themselves out of cases that they don't belong in. But you hear them all the time on writs of prohibition. They happen every day in the criminal courts, and we attorneys address these issues on an everyday basis. But that's really a foundation of why I believe this, I'm hoping the court will take under its discretion to make a decision in this case, because we need guidance. If we didn't need guidance, I wouldn't be here, because I don't believe, one, this would have happened, and two, we would have known what the outcome would be. We would know what to do as victims, as people and as citizens, when a prosecutor is grossly going beyond and breaking the violations of the rules of professional conduct.
But didn't the legislature speak to the rights of victims and didn't include what you want to include? Shouldn't we be guided by that?
Well, first of all, the Constitution spoke to it. The Missouri Constitution speaks to it, and yes, the statutes speak to it. They say, but they're the victims' rights in Missouri under statute are the most toothless statute and wordplay ever given by.
But we're not the legislature.
Yes, and I believe that that is another outcome that would have to be changed, but that would be also by Supreme Court rule to allow intervention in a criminal case potentially by a victim. They are an obvious third party who can be harmed under the rules, but there is no right of a third party to intervene in a criminal case. Leaving the only option in the world, a writ of mandamus, in the situation that we're in, which
But even with
is
the
a
writ of
beast of its own, for lack of a
But even with the
better
writ of
way to put it.
mandamus, though, aren't we then guided by what rights the victim has? The victim is trying to enforce those rights through a writ of mandamus. So do we not have to first look at the constitutional provision, which is 32.1, or the statute, which gives certain rights to the victim?
Well, we have two different
No, is
aspects.
that, will you agree with that?
Yes, I
Does
would
the con-
agree.
So does that constitutional provision or any statute give a victim the right to seek the disqualification of a prosecutor if they believe the prosecutor is not adequately pursuing the case?
No, I don't believe, under the statute, a victim, no one ever could have a cause of action. Under the statute, there is no, like I said, when I said there was no teeth, it
Well, I'm talking about,
expressly forbids
I'm
it,
talking
I
about the
believe.
Constitution.
Well, the
You referred to the
Constitution-
Constitution, and I'm reading it right here.
Yeah.
Not just a statute, the Constitution passed by the people of the state of Missouri. Does that Constitution give a victim of crime a right to seek disqualification of a prosecutor?
I would say it does if the rights it violated also violated the rules of professional conduct. I think making a mistake, I don't think would ever, I think prosecutors are human, we're all human, and when we're giving advice and telling what the law is, we can all make mistakes. It happens on a daily basis. So in this case, what I'm trying to say is, if he would have said once that I think this is an 85% crime, but checked and changed his mind, or I think that he might not have been strangled, let me check, but he outright lied.
But-
and when you can prove these facts, I think you rise to a writ of mandamus at that point, because it's compelling him to do his duty. He created the duty.
All of these students here have already sworn allegiance to the rules of professional responsibility. And you know who they swore them to?
Supreme Court.
Supreme Court. We have no authority to determine on a writ of mandamus by applying the rules, violations of the rules of professional responsibility. That is strictly the terrain of the Missouri Supreme Court.
Let me return for a second to your argument that there may be a constitutional issue here. So the crime victims' rights established by Missouri Constitution do include the right to information about how the criminal justice system works, the rights and availability of services, and upon request of the victim, the right to information about the crime. I think two of these rights might apply to your circumstance, because my point is you claim false information was given about the facts of the murder, and also false information was given about what portion of the sentence would have to be served. Those seem to me to be information about how the criminal justice system works and information about the crime.
Yes, I believe those definitely apply. I would say the issue we have in general in this case is there has never been a case that addresses this. There is no guiding principles, and yes, the Supreme Court is the one who mandates the rules of professional conduct. But when a rule says a lawyer shall not, and I'm bringing a case for a writ of mandamus saying a lawyer's doing something they shall not have done for a terrible use of English, but you know, he's doing something that he's prohibited from doing. And I can have cited many other rule violations that also lead credence to that. I should have had a day in court. My client should have had a day in court and a chance and an opportunity to present evidence that this did occur. Instead, the halls of justice were closed. The door was slammed in the face of the appellants on a failure to state a claim upon which a cause may be granted. A 13-page decision on that, which should have just been a academic look into, did I express the 4 elements of the cause of action for a writ of mandamus, and therefore can I proceed? And he did not.
If I could then go back, and this has troubled me a bit, the accusations are very personal, very direct to Mr. Parks. And you wanted a writ of mandamus to order him to recuse himself in his entire office. Yes. He is now gone. It seems that, again, these were very directed just to this one person. Since he is gone, why is there an exception to the mootness doctrine? Are we supposed to presume that other prosecutors are going to act in this type of matter? Because you've been very specific about the violation of his professional responsibilities, the line or whatever, which I don't think anybody would want to assume prosecutors are going to, as a matter of course, do. So why does the exception to the mootness doctrine apply here?
Well, first of all, there is a public interest. Since we're in the law school, there's 2 reasons.
But the person of which you are directing all of these accusations is gone.
I do believe this recurs on an ongoing daily basis. This exact scenario, I don't know. But I think that as an attorney, every day a prosecuting attorney has to sit down and look and ask themselves on every case, do I have a conflict here? If they aren't asking that question, maybe they should be. Is it to the defendants? Is it to the state? Can I zealously and diligently prosecute the case in this? If they cannot, they have a duty to say, I can't do this, and somebody else needs to be brought in, period. And that's just the rules. That is part of being an attorney. So yes, that's why I think this happens all the time. Now, can I say 100% that everybody's violating the way I believe Mr. Parks did? No. Why? Because there are no other cases. I can never be able to see it. And do I think there's a chance that this court will ever have this controversy again? Doubtful. It's going to have motions to disqualify. Maybe somebody will follow my lead at some point and be successful. This is not a case I can say that I wanted to bring, and I really wish would have never had to be brought, because it would have meant that things went differently from the beginning. And I know we've gone way over time at this point, and I appreciate your patience. That's why there is justice for Ken, and that's why we're here today. And that's why we need a decision from the court. We need you to exercise your discretion. What's discretion? Because you want to. I'm at the mercy of, do you want to give me a decision or do you not want to give me a decision? Even if I fit all the rules of, if it's all, I meet the reasons why I should be allowed to have a decision on a moot case, I still have to get past the point of, will you please want to issue a decision in this case? That's justice for Ken at this point.
Thank you for your
that's
argument.
All we have.
You'll have 3 minutes in rebuttal.
Morning, Your Honors.
Wait a little till the room clears a little. Don't take it personally.
No offense taken.
I think you could go ahead and start now.
Great.
Thank you.
May it please the court, thank you again to SLU Law for hosting us today. I'd like to address, I think, right out of the gate, the mootness question, because I think that that's a threshold issue for this appeal. We just heard argument from counsel that essentially conceded the fact that this is a moot appeal. Robert Parks is a retired member of the bar. He's no longer the prosecuting attorney for Franklin County. He is no longer entered in any of the underlying pending criminal matters, only one of which remains pending today. The other 2 have been resolved. I think this can be affirmed on that ground alone. And I think that what we've heard essentially is counsel asking for an advisory opinion from this court as to what constitutes a conflict of interest for a prosecuting attorney. When we look at the relief...
I think he's asking for more than that. I think he's asking for us to define the rights of victims with vis-a-vis prosecutorial decisions.
But the relief requested here, Your Honor, on the writ is the removal of Robert Parks from these pending criminal matters and the appointment of a special prosecutor. And to the extent that that relief cannot be afforded because Robert Parks is not entered in any of those matters, I think that this is moot from the start. It's moot, I think, as well as two of those criminal matters underlying this case because they've been entirely resolved. One remains pending, as I said.
Let me ask a question about our standard of review. Assuming we decide we're reviewing this, so he files a petition in trial court and that petition for a writ that gets dismissed. So should we, on our review of it, take as true all the allegations in his petition?
Well, I think the writ proceeding is a sort of unique flavor of appellate law, as we all know. Essentially, a writ can only be heard on appeal under circumstances such as here, where it's been the preliminary order in mandamus has been issued by the circuit court and then subsequently denied as to the permanent writ. So this is the very narrow set of circumstances at all wherein we can even hear an appeal of a writ order. And considering that this was resolved via a motion to dismiss by the circuit court, I think that that we can construe those factual allegations as true for the purposes of assessing whether or not there's a duty to withdraw from the case.
Okay. So under what circumstances, if anyone, can someone seek removal or force the recusal of an elected prosecuting attorney under Missouri law, to your belief?
Well, my understanding, and I think the Missouri law is very clear on this, is that the person has to be a defendant to the criminal case. So if we look at the cases wherein removal of a prosecuting attorney has been appropriate, such as the State v. Boyd case, which was relied on by counsel in his briefing for this matter, in that case the prosecuting attorney had been a public defender at the time of the indictment, was not directly involved with the defendant, but had been with that office, then switched and was the lead counsel in the prosecution of that individual. And in those circumstances, that was inappropriate and that prosecuting attorney had been removed. And that's actually been codified by statute as well under Missouri law. That's section 56.110.
Could a trial judge who saw a prosecutor engage in corrupt activity and personally witnessed it, could a trial judge order the removal of the prosecutor?
What do you mean by corrupt activity?
Let's say he saw the defendant hand $10,000 in small bills to the prosecutor and the prosecutor sign a null pros. Could he order the removal of the prosecutor?
Well, the trial court has discretion, of course, to remove a prosecutor from the case as well. And I think that the underlying basis for that has to be some sort of direct conflict, direct relationship with the defendant. Okay. And that's what we've set forth in State v. Boyd. And when you look at the actual standard of review here, this court has made it clear that in order to state a writ of mandamus as to any public individual, it's reserved only for extraordinary emergencies, and it's up to the relator to articulate a clear, unequivocal, and specific right to the thing claimed.
So if a trial judge who personally witnessed corrupt activity could remove a prosecutor, why shouldn't the judge here have determined the truth or falsity of the petition before him and made a determination of whether there or not was some unethical activity going on?
Because the trial court, Judge Missy, looked at the allegations involved, and it basically cuts two ways. There's the conflict question, and there's sort of the diligence question, if you will. There's the civil lawsuit was filed by Ken Allen preceding his murder against the Franklin County Prosecutor's Office generally, and one of its assistant prosecutors. And that was dismissed after his death. Then there was the sort of diligence question, which was argued by counsel, which is essentially that Robert Parks didn't try hard enough to litigate this case, or that was too lenient in suggesting the plea agreement before the court. And I think that we already have to one level of review of that issue. The trial court has discretion to reject the plea agreement, and that's exactly what happened here. So I think that the remedy for what was described is exactly what happened, which is that the trial court hearing the criminal matter has the ability to reject that if it so chooses.
Well, yes and no, okay? Because my point is, first of all, the law has some remedies here. He can be thrown out of office at an election. Maybe that's sort of why he retired here. He thought he wouldn't stand for obviously, his license can be affected by the conduct. But here he's saying, yeah, but what do we do as to an ongoing criminal prosecution? And if we believe there's corruption or a conflict of interest afoot. So yes, it's true, a judge can reject a plea agreement, but for example, if a case is corruptly null prost, a judge can't review that, can he?
That's correct. And I think that's the rules as they stand relate only to the interest with the defendant, and that's because we place that as paramount under Missouri law, that the interests of the defendant come first.
So to follow up with Judge Mooney's questions, I had the same. So what recourse? I'm going to assume, just for purpose of this appeal, as you say, we have to assume the facts as pled, assume those facts are true, and there seems to be as pled, that something really is not going on here correct. For whatever reason, the prosecutor isn't aggressively, isn't doing his or her job in prosecuting the case. Then what you're saying is that there is really no recourse for anyone other than a defendant to seek any sort of action with regard to that, except through the political process, through re-election, or to file a bar complaint and try to seek it through the Supreme Court.
Because I think that the problem is that we create a sort of unworkable set of circumstances where general members of the public, if they're unhappy with the direction of a specific criminal prosecution, can assert, all right, well, someone else from a different county should prosecute this case. And that's a political solution to the problem, is that we should elect a different prosecutor. Or the judge who's hearing the criminal case, who's most involved with the criminal case, has the authority to reject that plea agreement.
Reject the plea, and the prosecutor comes back and says, fine. Then I'm just going to, as was mentioned, dismiss or nollie pros some of the charges. All that's left is the involuntary manslaughter, and that has a maximum of 7 years, so Judge, you can't do anything anymore.
And I think that's the result that we have.
Exactly. Is that, yeah, so basically kind of turn the tables on the judge, saying, the max is 7 years. Now we have nollie pros the other charges that could have potentially given much more time. And so now, if accept the plea or not, because the most he's going to get a trial is 7 years. So essentially, the prosecutor, if assuming the facts as the underlying motives were wrongful and for whatever reason, what recourse then does the victim have?
Well, I think that the results have been, that result has been reached several times, and both by this court and by the Western District. And two of those cases that we've cited in our brief, one was the State Ex Rel. Bennett v. Ravens. The Western District addressed circumstances under which it determined that the prosecuting attorney was not doing a good job of representing the state of Missouri. That was the language from the opinion. And it removed the prosecuting attorney, and it was held upon review by the Western District that was improper, and actually a writ of prohibition applied to the circuit court for reaching into and controlling the conduct of the prosecutor in that case. A similar result in this case, involving also Mr. Parks, by this court, was that State v. Eckelkamp case, which I think has already been discussed in terms of the circuit court's ruling in this case, wherein the court held that it was improper for the circuit court to look at mandating Prosecutor Parks to enter into plea negotiations when he was not otherwise inclined to do so.
So you're saying, and we're not talking about Robert Parks, I'm just talking about in theory. So we can remove and impeach presidents and chief justices and the rest, but there's no remedy that exists in law if there is, in fact, a corrupt prosecutor?
Well, those are political solutions to what we're talking about in your example as well, and there's a political remedy available here if the people of Franklin County were so inclined to.
But my point is, the law gives us other options beyond the political remedy as to the president, as to the judiciary, but not as to the prosecutor. Is that your belief?
Well, the appellant here, the relator, who has the burden to show an unassailable, unequivocal, absolute right, has not articulated that and has not demonstrated any entitlement to that under Missouri law, and I think that's the standard of review that we have before us.
We are a court of review, and we review exercises of discretion by the trial court all the time. We review exercise of discretion in cases that are before the trial court. And that's the troubling thing here, is with regard to a case that has been brought into the system by an arrest, and it may be a warrant issued, that the prosecutor then has unfettered. There must be a limit to that discretion.
And I think that there are procedural safeguards that are afforded to the defendant, because the defendant's rights are the paramount rights under the system. And
right, but the defendant is never going to complain about a nollie-pros, a decision not to prosecute. Let's take these facts. A prosecutor is elected and proceeds not to issue a case. Just refuses to issue any case, does not prosecute. Is that what happens then?
I don't think that it's controllable by mandamus, and I think that the crime victims constitutional provision that we've discussed is on point with that. If we look past the first section of Section 32, which sets forth the enumerated rights, there are several other subsections that I think are relevant to this case, particularly number 3, which is that nothing in this section shall be construed as creating a cause of action for money damages against the state or any of its agencies. And I think the more important one is subsection 4 of Section 32 of the Missouri Constitution, which basically sets forth that nothing in this section shall be construed to authorize a court to set aside or void a finding of guilt or an acceptance of a plea of guilty in any criminal case. So the constitutional provision, which is relied on by the relator, also sets forth that nothing in this provision shall entitle a court to step into the plea agreement stage, because the relationship between the defendant and his rights and his ability to negotiate that with the prosecutor.
Okay, I'm going to give you one more hypothetical. Since we're at a law school, we get to do this. So a prosecutor, shortly after he's elected, suffers a brain tumor and becomes completely psychotic, okay, and says, I'm only going to prosecute Martians from here forward. Does the law have no remedy?
I don't know that the law has no remedy. There's certainly a political remedy, as we've discussed already.
Well, these terms are oftentimes 4 years, so my point, for 3 years, 11 months, there's no remedy?
I don't think that there's a remedy to an uninterested third party to the lawsuit to enter into and demand removal of the prosecutor for a specific case, which is the request for relief that we have here. We have a third party who was not a party to the civil lawsuit at all, who is not a party to the criminal litigation, other than Kathy Allen's involvement as a victim under the constitutional provision, who's seeking to essentially backseat drive the prosecution. And that's an unworkable set of circumstances for any county in the state. And that's the relief that's been requested here, which they had the obligation to articulate as the relator on a writ of mandamus. If I could briefly speak to the standing issue, I think that that's also related. They're a citizen group, unincorporated under Missouri law, and they have articulated no other individual interest in the case beyond their citizen group and Kathy Allen's status under the crime victims constitutional provision. If there's any questions, I'd be happy to take them. Thank you.
Thank you very much.
May it again, please, the court. I just want to start off by being very clear, because I don't like to argue in this situation, but Missouri law isn't that defendants' rights are paramount. Missouri law and Constitution is very clear that victims' rights are paramount to defendants, period. No question. That is an open and shut case. The victim has more rights, and that is the highest priority in this state. So it shouldn't be falsely told to a law school that defendants' rights are paramount ever, because they aren't in this state. That's just how it is. Like it or not, victims' rights are higher than defendants' rights, except in this case. It's also interesting that they cited State v. Boyd. State v. Boyd says some very interesting things, if you can give me just a moment to quote. One is, a prosecuting attorney is a quasi-judicial officer, and his duty to avoid an appearance of propriety, it has a duty to avoid an appearance of propriety. We're asking in a writ of mandamus that duty be enforced. It also says that there should be strict avoidance of any appearance of impropriety. And it is also worthy of note that these statutory and ethical restrictions as to a prosecutor are not couched in terms of prejudice to the accused or the state, but are rather directed to the public welfare and need that prosecutorial conduct be beyond reproach, criticism, or the appearance of impropriety. I think that sums it up.
But where's the remedy in there?
The remedy, one is a writ of mandamus, what I brought. That is the only remedy in my situation. The other is, and I feel awful because I did not make notes on this, a citizen could have filed a complaint against the prosecutor in writing in the county.
Could have done one
against an elected official under Missouri law. Normally, if that's anybody else but the prosecutor would then open a file and investigate if that elected official had done something, if there should be a removal proceedings. In a prosecutor's case, it would go to the Attorney General's office to investigate. Why that wouldn't necessarily be applicable in our cases, there's no way that remedy would have been quick enough. That's why writ of mandamus was the only remedy available, because getting an investigation from an Attorney General and getting a ruling 6 months down the road or a year later from an appellate court does not prevent the action from happening in the first place. Our cause of action was about preventing unethical conduct and preventing an attorney from to compel an attorney to perform duties he was refusing to perform. The absolute underlying basis for a writ of mandamus. It's textbook reason why you ask for it is to enforce a public official to do one of their duties of office. And a duty of a prosecuting attorney is to follow the rules of being an attorney. It's as simple as that. If he's not following the rules of being an attorney, and we can prove that, we should have the right to bring a case to prove just that.
Thank you very much for your argument. The matter will be taken, heard, and submitted, and the court will be in recess. We would be happy to entertain questions, not about the case or the cases, but general questions about court procedure or being a judge. And the attorneys, if they would like to, are welcome to stay if they want to participate in this as well.
I'll ask one of the St. Louis U High students to start us off.